Good afternoon, everyone. My name is Francesca Guerrero. I'm a partner in Thompson Hine's International Trade Practice. I would like to welcome you to today's webinar. I'm delighted to introduce you to our panelists who will be popping in with their webcams soon. First is Josh Shapiro, a partner in Thompson Hine's Antitrust Practice. Next is Anthony Baldanza, a partner in Fasken Martineau's Competition Practice. And finally, Chris Worrall, a partner in Burges Salmon's Competition Practice. Before we begin, a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. We will be offering CLE credit for today's. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located on the right-hand side of your screen. The form provides instructions as to where to send the completed form, and I will announce the tracking code at the end of the program. This program is scheduled for an hour, so I will announce the tracking code at the end of an hour, but we may go over the hour when we have discussion and Q&A, but I will announce it after an hour. In the handout panel, you can also download a copy of the PowerPoint slides as well as bios of today's speakers. On the panel to your right, you will also see a question tab. If you click on that, you can insert questions that we will receive by text during the presentation. Please feel free to send us questions during the presentation. If we can answer it readily during the sort of overview section of the presentation, we will do so. If not, we will save it to the end when we have more of a discussion. But please feel free to send in questions. That always makes the programs more interesting. Again, thank you for your interest, and we will get started. So our first section will discuss UK review considerations. Then we will discuss Canadian review considerations and then the US, and then bring it all together for a discussion at the end. So I'd like to turn this over to Chris to talk about the UK.
Thanks very much, Francesca, and thanks very much to everyone for joining this webinar today. It's great that we're able to connect with you all like this. So in terms of what I'll be covering on the UK side, and also conscious of time, given that we only have an hour to discuss quite a lot, 3 regimes within that time. My main focus will be on the new UK foreign investment regime. But before I cover the new regime, I think it's quite easy to forget sometimes that the UK does actually have an existing foreign investment regime, which is also linked to the antitrust merger control regime in the UK. So I'll be talking a bit about that first, and also some recent developments. And then I'll move on to the new regime itself and explain why it will be so significant. So moving on to the next slide on the UK merger control regime. And just to put the regime in context, it is a voluntary regime, one of the very few around the world that is voluntary. But there's recently been increasing intervention by the UK Competition Authority, the CMA. Although it's a voluntary regime, the CMA has the power to call in transactions where the target has a turnover of more than £70 million, or where the combined shares of the parties is more than 25%. And the other thing to bear in mind is that as the UK is no longer part of the EU following Brexit, there's no longer the EU one-stop shop principle. So now businesses have to consider very carefully as to whether they might require an additional filing in the UK, where previously a single filing to the European Commission would have sufficed. In terms of the share of supply test and the market share test, that's been interpreted very widely by the CMA recently, and we've seen the CMA calling in a number of deals, including deals by US purchasers of companies where there hasn't actually been that much nexus to the UK. And the CMA has been quite active in imposing hold separates on parties, which prevents integration or closing even taking place before the CMA concludes its review. And I think what's quite surprising is that there's been around 30 or more detailed phase 2 CMA cases since 2018, and actually around half of these transactions were picked up by the CMA rather than being notified by the parties involved. And the CMA has been very focused recently on small tech type mergers and pharma deals where the target is relatively small, and it might be being purchased by a much larger company, and the CMA has shown that it's become very concerned about smaller, potentially more innovative and maverick companies being taken out of the market. And it's those types of cases that where we see in the CMA trying to extend its jurisdictional reach as much as possible. In the context of COVID, what we've been seeing is an increase in the number of accelerated or distressed M&A transactions, as you can imagine. And I suppose when you put merger control next to accelerated M&A, it does seem a bit of a contradiction in terms, given that the merger control approval process usually takes so long. But it is actually possible to obtain merger control comfort, at least on certain transactions, quite quickly. What we've been seeing is a lot more use of the informal briefing paper process to try to get around lengthy CMA timetables. So it usually takes around 3 or 4 months at least to obtain CMA clearance, whereas under the briefing paper process, parties can submit just a very short informal briefing paper to the CMA explaining why there are no substantive issues and why a full notification is not being made. And that's with the aim of receiving informal comfort from the CMA that it will not open a formal investigation. And this process, which can actually be significantly shorter at just around 2 to 4 weeks, has been really helpful in the context of accelerated M&A transactions where time is of the essence. Also in the context of COVID, we're seeing increasing use of the failing firm defence under UK merger control, and the CMA recently issued updated guidelines on the failing firm defence, making it clear, however, that it will continue to subject any failing firm arguments to its very strict criteria. And that's certainly been borne out in the cases we've seen, and I think Tony will be talking a bit about that on the Canadian side as well. Moving on to the next slide. So just under the UK merger control regime, where the CMA has established jurisdiction, the UK Secretary of State for Business, Energy and Industrial Strategy can intervene on public interest grounds. And as we set out in this slide, the way it works is that the Secretary of State issues a public intervention notice, and then the CMA produces a report which summarizes any national security concerns. And then it's really for the Secretary of State to decide whether to clear the deal or accept remedies. Moving on to the next slide, there are actually already a number of sectors in which the Secretary of State can intervene under the existing regime, and this list was expanded last year, where the target is active in military or dual-use products, computer hardware, quantum technology, artificial intelligence, cryptographics, advanced materials. The Secretary of State can intervene. And in these particular sectors, the Secretary of State can intervene on much lower turnover and share of supply thresholds, as we've set out here. And there is actually also a new category for intervention, which is where the target's involved in the fight against COVID or is a vaccine research firm or manufacturer of PPE. Turning to the next slide, it's worth mentioning that the last significant intervention by the Secretary of State under the existing regime was the Advent Cobham transaction, which is actually a transaction we worked on. And part of Cobham's activities include the provision of advanced mid-air refueling equipment for military aircraft. So it was considered to be particularly sensitive from a defence perspective, and as anticipated, the Secretary of State intervened on national security grounds. And actually one of the family shareholders in Cobham also complained and objected to the deal. And that's probably also what prompted the government to look at the deal more closely. In the end, the Secretary of State accepted remedies in place of a full investigation, which could have lasted potentially up to a year. And the remedies were relatively standard type remedies. One of them was requiring at least 50% of the common directors to be UK nationals and residents, and also there was a requirement to maintain strategic capabilities in the UK. So that just gives you a bit of a flavour, hopefully, of the existing regime. And turning on to the new UK foreign investment regime, I suppose the first key question is, what is the reason for the new regime at this particular point in time? Why now? And it's been, I suppose, quite a few years now, actually, that there has been discussion of having a standalone national security regime in the UK to bring the government's powers in line with the national security regimes of other jurisdictions, including the US and Canada. And there have been various proposals and plans over the last few years. And I suppose finally it's coming to fruition, and the Prime Minister has decided to drive this forward at this point in time. Some people have asked, is this connected to Brexit in any way? And strictly speaking, it's not, because it's been planned for quite some time and prior to the Brexit discussions. But at the same time, it is part of the same theme of the government wanting to assert its sovereignty in the new world order, so to speak, and give the government more powers to review potential transactions which might go against or otherwise be hostile to the UK's interests. I think really what's striking about the new regime is just how wide-ranging it is. As we'll see in a minute, it covers 17 key sectors, so it's very wide-ranging indeed. What's also striking is that for the first time, it will create a mandatory and suspensory foreign investment regime, so that notification and review of certain transactions will be required prior to completion of any transaction that triggers the regime. And the government has estimated that up to 1,800 transactions per year will be caught under the mandatory notification system. So that's really quite significant. And to compare that to CFIUS, which I understand captures around 200 to 300 transactions per year, that really is quite significant. I think it's so significant that actually commentators in the UK are beginning to wonder where will all the resources be to actually start reviewing all of these transactions.
Yeah, Chris, I'll just interject there. I'd say the 200 to 300 number is probably full notices, and so I don't know that we have data yet on how many declarations, which we'll talk about later, are being filed. We've only had the process for about a year and a half. So that is one way, that one distinction in terms of resources.
Yeah.
I think that'll be interesting to watch, see how it develops.
Yeah, it is a very interesting point of comparison, and I suppose we might hear from Tony a bit later as well on the Canadian perspective as well. Just in terms of timing, the bill is currently going through Parliament, and the official line is that it's expected to come into force in early 2021. But we have actually recently been speaking with BEIS about a potential transaction that may be caught under the new regime, and they've actually told us it's more likely that the act will come into force in May this year, and possibly the regime won't fully enter into force until late summer. So I think that's much later than has been expected and formally communicated to people. Having said that, it is still worth having the regime on the radar for deals that are being contemplated now, simply because the proposed call-in powers are quite significant, and I'll come on to that in a minute. So turning on to the next slide. So what type of transactions are caught exactly? Well, there are a number of proposed trigger events, which of course are purposely designed as being very wide, and even transactions where a 15% stake is being acquired can be caught. And just to reiterate, where a transaction falls within the list of 17 sectors, which I'll come on to in a minute, a mandatory notification is required. There is also a voluntary notification system for other sectors, so activities that fall of the target falling outside the 17 sectors proposed. So that's another interesting point about the regime. And then another key point to note is that the Secretary of State, as I mentioned, will have this power to call in transactions. So where transactions are not notified, the Secretary of State will have the power to look back retrospectively over a period of 5 years, which is really quite significant. And if we just move on to the next slide. So the Secretary of State will be able to call in transactions that have completed from 12th of November 2020 onwards. So for that very reason, it is really important to start looking at potential transactions now to see whether they could be called in potentially at a later stage, and whether it actually makes sense to proactively inform the government about transactions now. And we've had some recent experience of that, where we have approached the relevant unit to discuss potential transactions and try to determine whether they might be interested in a certain transaction. They've been very helpful in giving us guidance on that, so it's certainly recommended at this stage. The other point to note is that it's not just about foreign investors. The regime will apply to investors from any country around the world, including the UK. And the key test is whether, you know, an acquirer might be potentially hostile, even if it's based in a so-called friendly country, whether it has any potential links with other hostile states, for example. And then in terms of timing of the review process, notifications will need to be submitted to a dedicated government unit called the Investment Security Unit. And the intention is for the Investment Security Unit to screen transactions, and the timing for doing that will be 30 working days, but that can be extended by an additional 45 working days. And I think, I mean, that does look quite ambitious to me. As I said, I expect that the new unit could potentially be flooded with lots and lots of transactions, and it will be interesting to see whether they stick to those deadlines. And I think it will be interesting to compare that with the timing on both the US and Canadian side as well, and see what the experience there has been. In terms of sanctions, I think there are very significant sanctions for failure to comply with the new regime when it comes into force, and the sanctions that have been proposed are fines of up to 5% of worldwide turnover, or 10 million, whichever is greater. And then there's even the prospect of imprisonment of up to 5 years and directed disqualification for up to 15 years. So it really is a very strict regime. Moving on to the next slide, you can see that the regime is very, very wide indeed. There's 17 sectors involved, so very wide ranging, and all of these sectors are currently being consulted on. So the specific definitions, proposed definitions in each of these sectors has been published, and it's currently going through a consultation process. And so, you know, certain of these areas sometimes not clear as to whether they will trigger the new regime. And certainly even at this point, we've been looking at certain definitions and wondering on certain transactions whether a mandatory notification might be triggered. And we've actually had quite helpful discussions again with BEIS to discuss certain of these definitions. And I think probably in the next few weeks, hopefully we'll get a bit more clarity from them, and they'll publish the results of their consultation, and we'll have more determinative guidelines and definitions from them. But that just shows how wide-ranging the new regime will be compared to the current regime. So I think I'll leave it there, and if there's any sort of specific questions, we can always come back to them at a later stage. And I think at this point, I will hand over to Tony to talk about the Canadian regime.
Thank you. Thank you, Chris. Thank you, Francesca. And hello, everyone. So the Canadian regime is, first let me say I'll be addressing both Investment Canada and the Competition Act. The Canadian regime, the Investment Canada regime, covers net benefit review, which is essentially an economic review, excuse me, and also national security review. So it's all placed in one statute. If you turn to in terms of the thresholds, this is a simplified schedule, but in essence, where there is an acquisition of control by a non-Canadian of a Canadian business, the strong likelihood is that it will not be subject to net benefit review because the review thresholds, as you can see, are very, very high. Indeed, with the exception of cultural transactions. In the government fiscal year ended spring of 2019, there were only 9 review applications for review filed, apart from culture, and there were another 9 in culture. So the vast majority of transactions were merely notifiable.
Tony, could you give a little more color on what cultural transactions are in this context?
Sure. So Canada has chosen to, this is really a preoccupation that goes back to the 70s with maintenance of Canadian culture in the face of, you know, the global presence of the U.S. culture and the desire to ensure that Canadian voices were being heard. So culture essentially focuses on the medium of communication, publication, distribution, sale of books, magazines, periodicals. There's the audio and visual component. So that's general, the general scope of cultural transactions. It is not the ballet or museums, that sort of thing, that is the preoccupation. And so the review thresholds for both culture and for non-world trade, non-trade agreement investors is very low at $5 million for direct transactions and $50 million for indirect transactions. So indirect transactions apart from culture and non-WTO are generally exempt from review. So that eliminates, you know, situations where, say, US company buys another US company, which happens to have a Canadian subsidiary. So as I mentioned, the review is based on economic factors. There are 6 buckets of factors. Employment is always a big issue. Participation of Canadians, the effect of the investment on productivity, industrial efficiency, technological development, innovation, etc. The effect on competition. And by the way, that assessment is outsourced to the Competition Bureau by Investment Canada. Compatibility of the investment with national, industrial, economic, and cultural policies, and finally, contribution of the investment to Canada's ability to compete. So turning to national security review, in contrast to the situation with net benefit review, where we've got these very high thresholds that save most transactions from such review, in the case of national security review, you ought to assume that any transaction that touches Canada directly or indirectly in terms of a business presence will be vulnerable to a national security review. And most transactions where there is an acquisition of control of a Canadian business will be merely notifiable, as I mentioned earlier. And it's that notice that will typically trigger that initial screen for national security concerns. A formal national security review is invoked only when the view is that the transaction could be injurious to national security. And as I mentioned earlier, there were only 9 such reviews in the fiscal year ended spring of 2019. once you have a formal national security review, you are into a potentially very prolonged exercise that can amount to 200 days plus. So I'm impressed by those in the UK who can complete those reviews in considerably less time.
Tony, I have a question. You
Yes,
mentioned
sure.
there are only 9 reviews. Do you have any sense of how many transactions were notified to net the 9 reviews?
Yes. Fair question. So there were just under 1,000 notifications in that fiscal year. So 9, it's a very small percentage. Now, I want to add that I've had many transactions where we notify, and there is an information request. There is a bit of an exchange with the agency, and that exchange in a relatively small percentage of that population has been quite substantive. So the national security review is in a sense the tip of the iceberg, but nonetheless, remedies are only ordered where there has been a formal review. So it is an important data point. So in terms of the national security review power, it's very extensive. The deals can be blocked, conditions can be imposed, undertakings can be negotiated, etc. But overall, I would say that the power appears to have been exercised judiciously to date. Now, something of an expansion, not a statutory expansion, but in terms of policy, if you will. In April 2020, the government issued a so-called enhanced scrutiny bulletin in the context of COVID. And essentially it said that there would be enhanced scrutiny applied to foreign direct investment in Canadian businesses related to public health or involved in the supply of critical goods and services. No surprise, really, but nonetheless, this enhanced scrutiny is there. Now, an important point, this enhanced scrutiny can only be under the national security provisions because there is no capability to apply enhanced scrutiny to non-reviewable, transactions that are not subject to net benefit review, which, as I mentioned, ordinarily is subject to a very high threshold and would catch very, very few transactions, specifically 9 in the fiscal year ended 2019. The other category that would be subject to enhanced scrutiny is acquisitions of control or acquisitions of any sort by state-owned enterprises. And there, the government will be focused on the commercial orientation of the investment. And that is the SOE acquiring the interest for commercial purposes? And will it behave commercially? Or is this a government strategic initiative? And let's see. I can get into, the sort of industries and businesses they focus on, but perhaps I'll leave that for questions, just mindful of time. So to all of these issues do urge appropriate due diligence at the very front end of a transaction. And I know Francesca will be discussing more of this, more on this topic, but at a very high level, both buyers and sellers want to take a good look at the buyer and its influencers, shareholders, their percentages, shareholder agreements, org charts, contractual obligations, loan arrangements, lenders, veto rights in favor of any government, for example, entitlements to nominate directors, all of those sorts of things. Also, you'll want to take a very close look at the target business and its assets. Does the business involve the supply of critical goods, Does it service or supply critical infrastructure? Are controlled goods involved? Is personal data involved? Are assets located close to sensitive installations, for example, military installations? And also the nature of the transaction itself. There is certainly a gulf between a minor limited partnership interest and a controlling interest in a business. Both are in theory subject to the national security provisions, but one is much, much less likely, even with the same business, to trigger a national security review than the other. Turning to mitigation, I understand that mitigation is a very significant tool in the United States for essentially navigating a transaction that poses national security concerns through CFIUS. What I would say is that Canada has the statute, Investment Canada Act has the legal structure to provide for mitigation, and there was a reasonable amount of mitigation occurring some years ago. But in the last several years, the strong sense is it's been a zero-sum game. You either don't present, you're either viewed as not presenting national security issues and the transaction is cleared, or if you do, the transaction is blocked. Now, I don't want to be overly categorical, and I would view this as an opportunity for purchasers, but don't presume that you can mitigate and address mitigation. Think about mitigation right up front and what can be mitigated, how, and what happens if mitigation isn't realistic. Turning to the Competition Act, and I'll be very brief on this front. So a few things, like the US, Josh will be covering this. The transaction threshold for mandatory notification has reduced from 96 million to 93 million. That's a reflection of the slight contraction of the Canadian economy in the context of COVID. But I want to emphasize that non-notifiable transactions are vulnerable to challenge up to 1 year following their substantial completion. A couple of other categories of points. First, some more COVID, if you haven't had enough of COVID. When the pandemic, at the front end of the pandemic, the Commissioner of Competition urged merging parties to plan for delays, expect delays, and that the Competition Bureau would not meet the customary service standards. In fact, I do urge parties to plan for delays, but the Competition Bureau's performance has been better than expected. They were anticipating challenges in consulting the marketplace in terms of party submissions, in terms of receiving responses to information requests and the like. But like business, I think they've been pleasantly surprised at the ability to do business offsite. Failing firm factor. So in Canada, unlike I think in the US where it's a defense, in Canada, and Josh will correct me if I've got that wrong, failing firm is a factor, merely one factor among many. And the important point here is that the Competition Bureau has recently communicated their intention to adhere to the standards, which are rather high standards, to demonstrate that the failing firm factor exists and that a transaction does not pose a substantial lessening, or does not pose a risk of substantial lessening or prevention in light of that. So no competition light, to quote the Commissioner of Competition, who who announced a similar view back in the 2008 financial crisis. Efficiencies are also expected to become to be the subject of more submissions in the defense of mergers. Here I want to point out that unlike the US, and I think unlike virtually every other jurisdiction, Canada has an actual defense to anti-competitive mergers where the mergers give rise to efficiencies that offset and outweigh the anti-competitive effects of the transaction. These are not difficult, these are difficult to cases to make by merging parties, and invariably involve substantial economic evidence. And the Competition Bureau has essentially established a timing agreement, a model timing agreement, which they will ask parties who plan to advance the efficiencies defense to adhere to. The implied threat is, it's actually more than implied. It was expressed in the material that preceded the timing agreement, that if parties don't adhere to a timing agreement and don't enter it, that the Bureau will have no choice but to challenge the transaction. We haven't seen that yet, but so that's in terms of COVID things. I'll close out on tech. Tech deals are a priority for the Bureau. They are worried about killer transactions, and in particular, transactions that fall under the radar that are not notifiable, but yet pose very substantive competition risk. And tech is a priority across all aspects of Bureau operations, abusive dominance, monopolization, cartels, but also mergers and deceptive marketing practices, I would add. But in the context of mergers, I would say that you do want to be cognizant of the fact that even small transactions may raise merger issues. I'll stop there. Thanks very much.
Thank you, Tony and Chris. You all have been doing such a great job keeping us moving. I feel like I'm on my mettle now to move quickly through this material. So I will, you know, like I said, move quickly and presume a certain familiarity with CFIUS in the United States. Briefly, it's an interagency committee that reviews transactions involving foreign direct investment for national security risk. So unlike in Canada and the UK, the competition and sort of antitrust regimes and agencies are very separate from the national security review agencies. There was a major expansion of CFIUS jurisdiction in 2018, or with the 2018 NDAA, that extended jurisdiction from acquisitions of control by a foreign person to a number of what I call non-passive investments. And we'll talk about, you know, what those are in a second, as well as real estate in sensitive areas. And I won't talk about real estate very much, except to say that the regulations they pass make it very clear when you have real estate and a sensitive area that's subject to CFIUS review. So, you know, if you know where your real estate is, you can figure out if it's subject to review. Whereas the other rules are more complicated. Then last year in February 2020 was the sort of final rule implementing FIRMA, and since then, you know, the provisions have been fully in effect. So what's a non-passive investment? As we just mentioned, for decades, CFIUS has had the authority to review any acquisition of control of a U.S. business by a foreign person. And they've always taken a very expansive definition of what control is. It's not, you know, 50%. It's certain rights that allow you to control business decisions. But the expansion of CFIUS covers certain rights that an investor has in a TID U.S. business. And those rights are access to material, non-public technical information, membership or observer rights on the board. So I would say it's very common for strategic investors to ask for a board seat or an observer seat in the past, and we've seen some trends where that changes because of this rule, and any other involvement in substantive decision making regarding the TID. So, just an example of something that you may not think would be covered would be like a seat on an LPAC, where the Limited Partnership Advisory Committee of a fund has the right to approve certain decisions, maybe approve the general partner compensation. Those actually are considered the types of rights that would trigger this. And one thing I'd like to talk about in the discussion is that I have seen companies going out of their way to structure their investments to avoid this jurisdiction. So I'm curious what you see in the UK and Canada. And honestly, it sounds like in Canada, there have been way more notifications than ever in the United States, even under our expanded rules. And it might be because people aren't as concerned about a vigorous review. They think that will be more limited. But in any event, those are the triggering rights. What's a TID US business? It's one that produces or develops critical technologies, which are generally defined by reference to export controls. So like your dual use technologies, like semiconductor manufacturing or semiconductors, as well as your defense technologies, nuclear equipment, and then also companies that perform certain critical infrastructure functions. So that can include telecom infrastructure, financial services infrastructure, as well as your sort of brick and mortar type of infrastructure like transportation and roads. And then importantly, and of really kind of a lot of interest in the last year or two, is companies that have sensitive personal data of US citizens. And this is taking a lot of investors by surprise because it includes like software apps, and it includes hotel chains that take reservations, and it includes a lot of companies that have not considered themselves sensitive businesses in the past. And it's a key area of interest to CFIUS. As Tony mentioned, I wanted to spend a little time talking about how the changes in CFIUS have made investor diligence, or KYC, so critical. I think most people are sensitive to the idea that you need to do diligence on the target of an investment and try to identify whether it's a sensitive business. But because the rules are so complex now about when a foreign person has a right, directly or indirectly, that might trigger CFIUS jurisdiction, we've really been emphasizing with our clients, particularly fund clients, that it's important to do diligence on your investors, know who you have in the picture upstream. And, one of the key reasons for this is that FIRMA, as I'll talk about in a second, introduced the concept of mandatory notifications. So, where in the past, you may have perhaps even overlooked a foreign person in a fund structure that might trigger review. And the risk was that CFIUS would choose to review the transaction itself. Now, if you miss something like that, the risk is that you've failed to meet a mandatory notification requirement, and there's substantial penalties. So, just emphasizing investor KYC is critical. If there's a state-owned enterprise that has a substantial interest, that triggers a mandatory notification. Any foreign person who would be involved in a critical technology company, that triggers the mandatory notification. So investor KYC, very critical. I wanted to briefly touch on the whitelist, which is a set of rules that exempt certain qualifying investors from the UK, Canada, and Australia. First, the exemptions only cover certain covered investment requirements, and they don't apply to control acquisitions. But somewhat uniquely, I think, and very confusing, is that there are a number of disqualifying factors that can mean that an investor from one of these countries no longer counts as exempt because, for example, they violated U.S. sanctions, or they violated a past mitigation agreement, or they violated some other select criminal rules. And these violations are actually pretty easy. Like, you know, like if you only have to read like OFAC notices to see how often these violations may occur for British companies. And if this disqualifying factor comes into effect, it is retroactively applied for 3 years after, you know, 3 years after the transaction. It doesn't mean that retroactively a mandatory notification requirement applies, but it does mean that CFIUS can reopen something and look at whether they want to impose mitigation or take action. So be cautious with the use of the whitelist. Process changes that occurred with FIRMA. Again, they introduced this concept of a declaration, which is less than a full notice. And it's both voluntary now since last February. So if you want to make a voluntary notice, you can, a declaration, you can. But any of the times that there's a mandatory filing required, they are talking about declaration. So they don't mandate the filing of a full notification, they mandate the filing of a declaration. And if it's mandatory, it has to be filed 30 days prior to closing of the transaction. So that's obviously going to have important deal timing considerations. You know, another important process change to note is that they introduced the concept of filing fees, which CFIUS never had. It's a sliding scale up to 300,000, mostly based on the size of the transaction. In terms of timeline, you know, here's the formal timeline if you're talking about a full notice. You know, there's a pre-filing period before they accept the notice as complete. And there's often basic questions asked during that period. You might choose to engage in pre-filing discussions even earlier, and we'll talk about that later. But the initial review period is now 45 days. If it goes to an extended investigation, it's 45 days up to 60. And then, you know, if they make a recommendation to the president, there's 15 days for him to decide. But in practice, if there's a highly contested transaction or one where there's significant mitigation, it can, the timeline can increase. You can be asked to withdraw and refile. There's different ways that the timeline can increase. So it may take 6 months to a year for a very complicated transaction, you know, even longer in a few cases to go through. I should mention also that if you elect to file a declaration, CFIUS is not obligated to give you a decision. And in fact, I just was jotting down the report from 2019, which is when the pilot program was in effect. There were only 94 notifications filed, 94 declarations, fewer than there were notices filed. 26 of those, CFIUS asked for a full notification. So almost a third, they asked them to then file a notification. So they kind of tacked 30 days on their timing. And 32, CFIUS said that they were unable to make a decision based on the declaration. They kind of left it up to the parties whether to file a full notice. And in 35 of them, they cleared the transaction. So I could go on and on about declarations, but I will move on to the next slide. I also wanted to highlight that there has been an increasing emphasis on mitigation at CFIUS. They have increased staffing. They now have a whole team devoted to developing and monitoring mitigation measures, you know, within CFIUS and also at various agencies who are part of the committee. Different agencies seem to take the lead on different types of mitigation measures. So DOJ is often like the cyber, like the data protection kind of agency, but DOD can have a role in that. And DOD takes the lead in other mitigation agreements. I think that, as I mentioned, data is one of the ones where we've seen a real increase in mitigation where parties, you know, promise to keep certain data in the United States on separate servers. They might have a security officer or even an outside monitor monitoring the protection of the data. But then there's more traditional mitigation like continued supply of the US government, you know, appointing certain people to monitor the security focused aspect of a business, things like that. And there are significant penalties for failure to comply with mitigation. That said, I think that there's a culture of compliance around the mitigation agreements where, because there's security officers or outside monitors, violations are regularly notified to the agency, and generally the emphasis is on fixing them. So I think that the concern with mitigation is less that you might be subject to penalties if you don't comply, but more that you may have to take a lot of time negotiating and figuring out what it is with the government, so that'll affect your deal. And two, it's a post-closing cost that you shouldn't, refuse to, forget to consider when you're thinking about the value of a deal. You'll have to maintain this data, perhaps pay a monitor, things like that post-closing.
I've just seen a question here, Francesca. I don't know if you've seen that, which is asking for an explanation in a bit more detail as to what may constitute a non-passive investment.
Sure. So let me scroll back to that quickly. So a non-passive investment is where any foreign person, directly or indirectly, has one of these, three rights that are on the first part of this slide in a TID US business. So first you have to have a US business that meets one of these thresholds: technology, infrastructure, or data, right? So if you have a company that's producing, canned goods, that's probably not going to be a TID US business. So they don't need to worry about whether they meet the non-passive investment threshold. But if you've got like a technology company, a software app that has lots of personal data, you do need to look at this. And the thresholds, like we said, like access to material, non-public technical information, that's going to be like the right to access something like beyond the financial statements that's related to the technology, or related to the data and the plans for using the data. Membership or observer rights in the governing body is kind of self-explanatory. But somewhere either in that bullet or in the one about substantive decision making is where you get things like a seat on a limited partnership advisory committee that has certain rights to influence decisions. So a lot of the sort of non-passive investor rights are the kinds of things that strategic investors often look for. And interestingly, the trend after the introduction of FIRMA that I have seen is that the general partners push back on this, and the acquisition of these rights has been more limited. That's kind of what I've seen the market doing. I am curious to see as things develop whether strategic investors and the companies they invest in will more and more make the decision, we're going to go ahead and file. We don't think it's going to be a deal breaker to have to submit a declaration or a notice. But I think one reason we only sold 94 in 2019 is that a lot of deals that might have tripped this because you had like someone investing in a technology company, 15%, 20%, whatever, and wanting a seat, they gave that up and they walled themselves away in the agreement from triggering these. So, but I want to turn this over to Josh so that he can tell us about antitrust, and then I'll read the CLE and then we will go into our discussion.
Great, thanks Francesca, and thanks Chris and Tony as well, and for all the attendees. I'll be relatively brief. I'm mindful that we're running up to the hour. Obviously, this is a lot to cover in an hour, and I think everyone knows that U.S. antitrust is very important, notwithstanding that we're the sort of the crux of this presentation is on FDI issues. But there is a lot of interplay between the two, which is why we've included this. And I just want to give a brief sort of, where are we right now with U.S. antitrust law? Obviously, we're sort of in the first couple months of a new administration. There's lots of speculation right now about what the leadership at DOJ and FTC will look like, and really Biden's specific enforcement priorities will be, what those will be. As folks probably saw, Merrick Garland is had his confirmation hearing the other day. Merrick Garland's actually interesting for antitrust. I think he began as an antitrust professor. So antitrust is near and dear to his heart. And really we'll probably start to see the leadership within the DOJ antitrust division and the FTC, Bureau of Competition and the chair of the FTC sort of solidify after Garland is, well, for Biden's perspective, hopefully appointed by the Senate. Biden, I would say, is already under a lot of pressure from progressive critics of corporate consolidation to avoid appointing lawyers really with ties to the industries that will be tasked with overseeing. So, he's going to be, the Biden administration is inheriting two very large antitrust matters lawsuits, really. One against Google, brought by the DOJ, and one brought against Facebook by the FTC. And there was really considerable pushback following press reports of a short list of nominees for the head of the antitrust division at DOJ, which included outside counsel for prior outside counsel for Google and Amazon. Surprisingly, there's actually some bipartisan support on both sides. So on both sides of the aisle for antitrust regulation of big tech. There's slightly different reasons for that, but all in all, I think what we're going to see is strong antitrust enforcement under the Biden administration. In addition to that, there's also potential legislation coming down the pike. Now, you can sort of place your bets on how likely that legislation will be. Senator Klobuchar, for example, has introduced bills in the past. It's a little different now. Senator Klobuchar is going to be sitting as the head of the Senate's antitrust subcommittee. So this is obviously, there's a little more weight behind this. This is a pretty remarkable bill she's introduced. It would amend Section 7 of the Clayton Act, which currently forbids mergers that substantially lessen competition. It would change that standard to a standard of create an appreciable risk of materially lessening competition. So that would lower the standard. And then for certain deals, actually the burden would be placed on the merging parties. Right now it's on the government to prove that the deals don't lessen competition. That would be for certain deals where transactions valued at over $5 billion, where there's high increases in concentration, as well as deals involving the acquisition of nascent competitors by a dominant firm. I think what you will see, regardless, is and Merrick Garland discussed this at his hearing yesterday, a boosting of funding for the DOJ and FTC. Currently, I think everyone agrees that it's not quite sufficient to do what they like to do. Now, one thing I'll say is that again, this proposal by Senator Klobuchar comes on the heels of a report from the Democratic House Subcommittee recommending sweeping changes as well to the antitrust law. So there's momentum here for some big legislative changes. If we could move to the next slide. Tony mentioned this before, but just as in Canada, the size of transaction, HSR size of transaction thresholds change every year. It's based on a change in gross national product. I think this is the first time, I believe, since 2010 that since the aftermath of the 2008 crash, there was a retraction of economy, change in gross national product. So now the new thresholds are $92 million. And that sort of applies to any deals that close on or after March 4th of this year. Obviously, lower threshold catches more deals. I would mention here, and this is something I always bring up, that a reminder that, unlike some jurisdictions, the U.S. antitrust agencies, the FTC and DOJ, have the authority and the remit to challenge non-reportable deals as well as reportable deals, as well as consummated deals that underwent HSR review. So, and there's no statute of limitations. So it's sort of a lot of power grants to the FTC and DOJ. So it's always wise, even if you have a deal that's below the threshold, to make sure you're assessing substantive antitrust risk. The other sort of big sort of development here is there's recently been a suspension of the FTC's early termination program. It's originally couched as a temporary suspension, but there were dissents from the two Republican commissioners, FTC commissioners, suggesting that this was indefinite and noting that this would be a big burden on the parties. So at least for the time being, it may portend greater antitrust enforcement of potential deals that previously maybe we thought would fly under the radar, were no issues deals. But regardless, for the time being, the 30-day waiting period is really the rule of thumb, and you can't count on early termination. I know we're approaching an hour. I don't know if we're going to read the CLA stuff or move on to the next slides, but
let me read the
yeah.
CLE quickly. So if anyone needs to drop, they have this. If you're seeking CLE, the tracking code is SmarTrade 2021. That's SmarTrade without, you know, 2 T's. It's at the bottom of our slides. SmarTrade 2021. Thank you.
So with that in mind, we're going to hopefully folks can stay on for a few minutes. You know, might be interesting to discuss some of these after we've sort of gone through these 3 regimes, discuss some deal planning considerations. And with that in mind, Francesca, I was wondering if you could speak a little bit about, you know, how CFIUS and just generally foreign direct investment issues play into due diligence, deal due diligence.
So, you know, I think I often get the question, you know, can you do a smell test and tell me if this is going to raise national security considerations? And I like to tell people that that's only true if the answer is yes. If it's not obvious, you know, on its face, then I definitely recommend that parties do diligence early on in the deal. You don't want to come up with an issue late in the game. And typically we try to be pretty targeted, you know, ask narrow questions before we dig into any issue. But, you know, we want to identify critical technologies early on. We want to identify sensitive personal data, you know, early on. We want to identify if there's government contracts, you know, real estate issues. And you know, this is because if there is a concern, as we'll talk about with timing, you want to be prepared for that as you're planning the deal. You want to be able to get your mandatory notification in on time.
As long as we're still on the political, there was a question asked earlier through the portal. How political is a CFIUS remit? In other words, do they take noticeably different approaches depending on the political party in charge?
I think not. I think you know, the expectations of the Biden administration will probably be pretty similar in terms of what they review, what mitigations they impose. There is bipartisan emphasis, for example, on being kind of tough on China. That said, I think procedurally there might be a slightly different tone. You might see a little less in the news. And you know, with the Biden administration's emphasis on multilateralism, I think that you might see even more work with like the UK and Canada and some of our like closest allies to bring our processes into alignment, maybe share information.
Chris, I was wondering if you could talk a little bit about sort of how, you know, now we've talked about FDI issues and antitrust, how this sort of plays into when you're negotiating the deal agreements and sort of some of the factors we consider and that come into play when you're working with the deal team.
Yeah, sure. So I think you know, these are all really, this is a really important point, and you can adopt a number of strategies when you're negotiating the SBA. But I think one of the key issues is what standard do you require the purchaser to meet when going through the clearance process? So, for example, should you adopt a hell or high water approach where the acquirer is required, for example, to take all steps or do absolutely everything to obtain clearance, including making any divestments that the regulator might require? Or should you have a sort of more of a best efforts type clause which sets out that the parties will both be making best efforts in order to obtain clearance, but that might not actually require them to go as far as giving remedies in order to close the deal. Now, if you do decide to go down the remedies route and actually sort of set out in the SBA what remedies might be acceptable to both parties in order to close the deal, that can give rise to issues in itself, because if you do that, then that can be often a red flag to a regulator who has the power to actually review the SPA itself. So I think there's a number of issues that are relevant. I mean, one of the other things that's worth considering is if you do decide to think about remedies and what remedies might be required, if you are putting that somewhere, should you put it in the SPA or should you put that somewhere else? And I think certainly in the UK, there's often discussions between the parties as to whether it's possible to put that in some sort of other document or privileged letter between the lawyers in order to do that. But and that way it prevents disclosure to the regulator. But I know, for example, Josh, in the US, and that's certainly not something that's done, although it might be, Tony, in Canada.
It is.
Certainly people try that with side letters, but the government wants to see that. I mean, certainly when you put that in the SPA, for instance, as a roadmap as to sort of what the assets are, where the pressure points are for potential divestiture. Going back to hell or high water, I've certainly seen, at least in the auction context, that the auction draft of the SPA, so sort of put together by the seller, usually it's market to see hell or high water. Sort of regardless of whether there might be antitrust risk. I was wondering if you've seen that, Tony and Chris, in Canada and the UK as well. I mean, certainly maybe for cross-border deals we have, but specifically just if that's sort of market you think in your jurisdictions.
Yeah, so with respect to Canada, I don't know if I'd say it's market. It's not unusual. And from some law firms, I consistently see it, and others less so. I mean, you do have a range from, I do see commercially reasonable efforts quite a bit. I see something ratcheted up somewhat, commercial best efforts in every variation of those few words. Hell or high water is often placed where the issues are apparent. And the fact is, particularly in an auction context where completion risk is a major element in the decision of to whom the vendor is going to sell its business.
We have a question about break fees in the questions, and I think that the question of whether break fees are used often goes along with the question of what type of clause, what kind of best efforts or hell or high water to include. Are you all seeing those lately? Break fees?
Break fees? Yes, they're common. They're not routine. They're not. Let me step back. In foreign investment review, both break fees and hell or high water are less common in Canada. I won't say they're unheard of, but there is ultimately our decision making on national security, on net benefit review, is political. Or let me rephrase it, it's made by politicians, the governor and council, the federal cabinet. So hell or high water is arguably not the best formulation for in that context. In terms of break fees, I see them. They're much has to do with the risk appetite of the buyer, the circumstances, the amount of risk perceived in the transaction. So we're really all over the map there, and really how much investment and how much of a time period is likely to be involved in securing clearance.
From my perspective, I have seen reverse termination fees, which are those paid by the buyer if it can't consummate the transaction. However, I think typically you'll find that if a buyer agrees to hell or high water obligation, they won't also agree to reverse termination. It's sort of one or the other.
Yeah, I think that's very much the case in the UK as well, actually, Josh. And I think what's also interesting, we see a lot of hell or high water in auction context, and also in the private equity context as well. But as you say, it kind of often starts off in that context and then gets watered down a fair bit as the parties negotiate with each other.
Absolutely, and I think another factor is, if you are a buyer and you're decide whether to take on a hell or high water obligation, it's key that if you're going to assume that on your shoulders, you should be able to control the regulatory strategy. So sometimes that's something that, obviously gets negotiated later. It's sort of after you've sort of decided where the risk allocation from an antitrust perspective is. But really, that should be something you're thinking about. Because if you're taking the risk, you don't want someone else being able to decide, what to divest. Sometimes that's a point that isn't really fully appreciated until once you're in the discussions later on with the regulators.
Right.
Yeah,
I
and I think the final point really, as we set out on this slide, is making clear who is responsible for paying filing fees. I think, as we've heard from Francesca on the FDI side in the US, the recent inclusion of $300,000 filing fees, that's very significant. And of course, HSR traditionally has always been very high. In the UK as well, there is a filing fee to pay, which can be quite significant. So always worth making sure it's very clear in the SBA as to who will cover those costs.
Exactly.
I'd like to throw in a question before we kind of move on to post-closing. A new question we haven't really discussed. I made some comments earlier about how I've seen a lot of negotiation early in the deal to structure a transaction to essentially avoid CFIUS jurisdiction, not like an evasion, but just to structure it so it's not within scope, especially when we're talking about strategic partial investment. And the investment like manager associations have even put out model language that in the United States that gives the manager of funds the ability to restrict the rights of investors if CFIUS review appears to become an issue. Have you seen anything like that in the UK or Canada?
I have not. That said, I'd say it does make sense that where, I mean, oftentimes the strategic essence of the transaction dictates that you're not going to be able to surrender very much in the way of investor rights and so forth. But at the margin, I can see some benefit in that. I simply haven't had occasion to witness it. So that would be a minority kind of transaction, typically. Minority, we have seen it in the antitrust world where, for example, where a particular investor is going to pose risk, you establish various walls, limit access to information, limit role in management, and so forth. This would be in the case of joint ventures, for example, where you might do that sort of thing. How fancy you get is really a function of the facts. So I see no reason why you couldn't. I just haven't seen it.
I think certainly on the UK side, it will be interesting going forward to see whether that will happen. I mean, obviously we're very at the initial stages of our new regime, but I suspect all sorts of provisions will be contemplated to deal with the new regime. And certainly in the UK, as I mentioned, the new regime does capture minority stakes even, so it can capture stakes of 15% or more. But it will be interesting to see, if that's looked at in a similar way in the US when you're negotiating the SBA.
Francesca, one other point that comes to mind, and that is I could imagine that would be part of a package of an effort at mitigating. So if there were concerns identified, in our case, by public safety, say through Investment Canada, that of the potential influence of a particular investor, then one might take those very kind of steps in response. So your language might need to allow enough flexibility to compel certain investors to essentially accommodate that kind of demand.
Mm-hmm. Yeah, it's just interesting because it's a clear trend, I think, in the United States. It's so interesting to see what you all find. We also have a question about whether CFIUS or other national security completion risk is insurable, and the answer is yes. I know some people who provide insurance on that, but it's not a kind of off-the-shelf insurance product. So it's there's usually a detailed analysis of the risk done. Did we want to move on to any other questions? Anyone who's still with us, please feel free to type in questions in the question box over on the right, but we have some of our own while we're waiting.
While we're waiting, maybe Francesca, if you want to talk a bit about post-closing mitigation.
Yes, so that is also something, as I mentioned earlier, can be quite, a real administrative cost and potentially a financial cost when you have a mitigation imposed that requires you to maintain like data in a certain way, hire certain people to oversee that. So I think it's important for companies to consider that when they are planning the deal, when they're negotiating the deal. Occasionally you'll be in a situation where post-closing you might require some assistance from the seller to carry out your mitigation, at least on a temporary basis. And so that should be something that is included in the purchase agreement where it's relevant as ongoing condition.
Tony, do you want to talk a bit about timing and sort of how this all fits, all these sort of the three-headed monster we've been talking about with the UK, Canada, and the US would fit together if you're dealing with a cross-border deal, and sort of how to sort of wrangle everything together?
Yeah, happy to. Thanks. So just some big points on timing. First, and some of these will just strike you as obvious, but I'll say them anyway. First is you want to get the right team in place at the outset where you anticipate substantive competition issues. You probably need economists. If you've got national security issues, you probably want GR persons and maybe a security specialist, national security specialist. And I don't mean a lawyer type, I mean someone out of the military or national security establishment. So you get the team in place. The purchase agreement, merger agreement should provide for, and here, I don't think Chris covered it. If he did, I apologize. Address timing of filings. When are filings to be made? Typically, it's fairly promptly after signing. The outside date for approvals, and this is a tricky item, particularly where you're dealing with many jurisdictions. You do have to think long and hard about what that outside date is going to be, and timing for response for information requests. I mean, you do want to compress that time frame if time is to be of the essence. So there are a number of levers, both in the purchase agreement and in planning, that ought to be pursued. In terms of coordination with various counsel, I mean, the key thing is identifying which jurisdictions are relevant right up front. And that is oftentimes a pretty laborious exercise. And particularly in global transactions involving many jurisdictions. And that can be a subject unto itself. I'm not going to go down that rabbit hole much further than that. Let's see, you had a couple of other points here. In terms of engaging regulators early in the process, that's something that needs to be considered. It's not always in the best interest of the parties to do so, but you definitely ought to turn your mind to the issue and not essentially decide you're not engaging the regulators through inadvertence, right?
Yeah.
So
I think certainly I think certainly we'd all agree that there's some deals where, keep your head down approach
Right.
is in order. But then there are other deals, if you're looking at for instance, a big, at least in the U.S., a big pharma deal, is going to get scrutiny. That there are overlaps.
Yes.
That you can still, it won't ruin the deal value if you do divest a product here or there, because you look at it on a product basis that you might go in early.
Exactly.
We have a question about clean teams and whether that concept is universal across jurisdictions. And this is something that comes up much more in the antitrust context. So I thought you experts could answer it.
Yeah. I'll start and then I'll kick it off to Chris and Tony. I mean, certainly it's a concept we see on a pretty regular basis in the U.S. I will say that, having worked on a lot of cross-border deals in some jurisdictions, again, outside of the UK, where I've found it's, pretty universally understood and expected in certain deals. In other jurisdictions, sometimes it's not. So you have to sort of make sure people are aware that'll be somewhat of an impediment to due diligence. And to be very clear, the clean team would cover access to very competitively sensitive information, like pricing and costs, and down at particularly at a product level.
Yeah, and certainly on the UK side, the position is that the CMA have been taking an increasingly sort of interventionist approach to any type of information exchange, including, during due diligence between competitors or potential competitors. And so for that reason, we always recommend some sort of form of clean team approach in the UK. And we're seeing it a lot more. We're seeing increasing use of clean teams recently.
Very, very frequently used in Canada, especially in the context of horizontal transactions. Less so where you're unlikely to encounter material issues.
I don't think we have any further questions over in our box that we haven't addressed. I'll read the CLE code one more time. It's SmarTrade 2021. That's SMARTRADE 2021. And any further questions before we close out? This has been a great panel. We really packed a lot in. And please feel free to contact us. Our contact information is included in the presentation materials. Also, if you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the publications tab, or my practice in particular has a blog, ThompsonHineSmarTrade.com. You can register for the blog as well. So thank you, Chris, Josh, and Tony, and thank you, attendees, for participating in the webinar. Enjoy the rest of your day and stay well.
Thank you.
Thanks very much,
Thank
all.
you very much.